Start. Para. At the outset, we take on record that the counsel for the petitioners in unison have stated that the petitioners do not attribute any motive or malice to the Election Commission of India, or for that matter contend that the electronic voting machines have been tutored or configured to favor or disfavor a candidate or political party. However, due to possibility of manipulating the EVMs, there is suspicion, and therefore this court should step in to instill confidence in the voters and the people. Voters have the right to know that the franchise exercised by them has been correctly recorded and counted. On a pointed question put by the court, it was argued without prejudice and in the alternative on behalf of the Petitioner Association for Democratic Reforms that the court should direct A. return to the paper ballot system, or B. that the printed slip from the voter verifiable paper audit trail machine be given to the voter to verify and put in the ballot box for counting. C. that there should be 100% counting of the VVPAT slips in addition to electronic counting by the control unit. Para. Other arguments raised relate to the alleged modification of the VVPAT in the year 2017, whereby the glass window on the VVPAT was made tinted instead of transparent, depriving the voter from knowing whether the vote cast by him was actually registered and counted. Rule 49 MA of the Conduct of Election Rules 1961 is draconian, arbitrary and contrary to law as reference to Section 177 of the Indian Penal Code 1860 in the written declaration under Rule 49 MA is wrong and misconceived. And lastly, the voter's right to know that the vote as cast is duly registered, being a paramount and indelible fundamental right. Any administrative reason and ground raised by the ECI objecting to 100% counting of the VVPAT paper trail should be rejected. Paper ballots were the norm till EVMs were projected as a viable alternative in 1980s. EVMs were first used in an assembly by election in Kerala in 1982. All through the 1980s and early 1990s, the use of EVMs for elections was discussed and debated by politicians and experts in the domain of technology and electoral process, and after due deliberations and review, the EVMs were accepted and embraced in view of the legal challenge regarding use of EVMs without legislative approval. The Parliament-wide Act 1 of 1989 amended the Representation of the People Act 1951, allowing the use of EVMs. They were used in the general election in 2004 and have been used in each and every general and other election thereafter. Para. ECI maintains that the EVMs have been a huge success in ensuring free, fair and transparent elections across the nation of all elections. They restrict human intervention, checkmate electoral fraud and malpractices like stuffing and smudging of votes, and deter the errors and mischiefs faced in manual counting of ballot papers. While earlier it was apprehended that the introduction of EVMs will lead to hardship, and independent studies showcase that EVMs have led to increase in voter participation. Yet, it is also true that time and again use of EVMs have been objected to and questioned not by one but by all political parties and others. There have been several litigations in this court and the high courts, albeit the challenges of the use of EVMs has been rejected, recording good grounds and reasons.